Probably not. I was wondering what the capacity is. Very cool.
Okay, yeah. Do we have results from the election? Good.
Michael, how are you?
Good. How about yourself? Good.
I would imagine so.
Okay. 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 I will point that out.
I have all the faith in Michael.
I'll try to help.
I think we're all kind of in it together. Oh, the little adjustment. Water feed. And so now it's not on my ear. It helps it keep so they don't fog up. It's going to take the glass and put it on the outside of the mask. But I only wear them because I'm old and blind.
Judge in the municipal courts, are y'all pretty much back to in-person appearances, or
Yeah, we never closed.
y'all were
So,
hardcore,
yeah, I
just
mean,
getting it done?
we didn't have dockets, but people could walk in and schedule, but we've been through, as soon as like last April, we started back. When they said we could start back.
Yes, we
back there, so. Still
Gotcha.
have a bit of a backlog, but we started back.
And how people, or how different groups would
Yeah.
not have a backlog, right?
Yeah,
So, absolutely.
we still, Harvard took out our whole basic, and we still don't have it. So we're sharing courts on the second floor. Because we lost 6 courts in the basement. When
huge
COVID,
hit.
yeah, so when COVID hit and social distancing, we just all went, what else?
No kidding. I learned to not say what else,
I
because
know, because you never know when
you don't know what's on the other side of that, you
This
know?
is true. Oh, we started.
I've asked just to make sure we think she's coming, and that's my understanding.
In hindsight being 2020, Judge, how are you?
Good, how are you?
I'm all right.
Live stream, right?
Shouldn't we have had a special meeting like 3 or 4 days after Glenn passed and then nothing, like fixed our chair, like had a permanent chair?
We don't. Yeah, I mean, we need to do that eventually, but it needs to be on the agenda to do that.
Right.
So, yeah.
I feel like it's kind of a weird thing to let sit for a month and a half.
Yeah.
And do you have anybody that starts in the event that she's not timely?
Not really.
Just wait.
I mean, we don't have a formal procedure for that.
I think we should, but yeah.
You're the most senior guy.
Well, I don't think we've
At an
ever,
unimportant meeting, I would be glad to start it.
I don't think we've ever really adopted
Yeah.
like Robert.
It's very different.
So we don't have a lot of formality
Yeah.
here.
If we have a consensus that we can start, I guess we can.
I know.
I will definitely get with you.
I'm actually,
We're in a consensus.
I personally would rather just go ahead and
Yeah.
Yeah, I would too.
have some framework.
You're good. Where you are? So you go.
I'll say what it says, yeah. I'll give him a second to get settled in. How do y'all feel about that? We have a quorum. Sure. We, in the past, I mean, for an uneventful meeting, we have just... We've just started to get things underway, and then eventually... I know. Here, you probably got here an hour before it started.
I'm gonna take a look, I guess.
With someone not acting as chair really, but just guiding the meeting, I would nominate Troy. Troy's been the vice chair before, so yeah. I'm gonna go ask him.
She's coming. I,
Just breathe, it'll be fine. Or it won't.
What they say?
I'm okay with waiting.
I'm fine with it, I just need to make it work.
Okay.
No, I'm not fine. I got other things to do.
Yeah, I guess I can just do it from here.
Yeah.
She was like the last time.
Yeah, that's kind of an every time occurrence.
Hope everybody else is okay with this.
Well, if,
If there are objections, we can object. Right?
To it.
Always.
yeah, I mean, do you want to check with Tommy?
With Tommy?
See?
Yeah, that's probably a good idea.
Yeah, let's just check with Tommy.
Tommy.
We have a question for you?
And how do we, don't we have to seat the new representative for?
Right, and just have, we don't have a, if Angela's not here, we just have Troy start, because I don't have a meeting if we don't object, and
Oh.
Let's just jump in.
Wait, we,
Oh, here's Angela.
Oh, here she is. Is she coming? She just left again.
yes.
Feel very happy not being on.
Yeah.
Yes. Thank you, Troy.
Well done. Or afternoon, whatever.
Yeah, you got it, Judge.
Good afternoon. Good morning. Oh, hello, sir. Hello. How are you doing?
How are you doing? Nice to see you.
Yes. Everything on the chair. Thank you so much, Mr. Mayor. Yeah, it's running images.
Thank you. Thank you.
Yes, ma'am.
Good evening, everyone. My name is Judge Angela D. Rodriguez. What's today? Today is March the 9th, 2022, and it is 1:43 p.m. I'm going to call the March meeting of the Harris County Bail Bond Board to order. And before I ask the board members to introduce themselves, I'd like to let you know that most likely we'll be saying a few more words about our chair that has passed on recently. We'll go ahead and leave that to next month. There's not enough words to fully honor that gentleman, Glenn Strickland. That being said, I would like the board members that are in attendance to please introduce themselves, starting with Ed Gonzalez, please.
Thank you, Madam Chair. Ed Gonzalez, Harris County Sheriff.
Dylan Osborne, Harris County Treasurer.
Elaine Marshall, Director, Presiding Judge, Municipal Court, City of Houston.
Michael Butera, sitting for the District Attorney's Office for Kim Ogg.
Judge Amy Martin, sitting for the felony district court judges.
Judge Shannon Baldwin, Harris County Criminal Courts.
Wes McCoy, representing Marilyn Burgess, District Clerk.
Catherine Case, representing Harris County Judge Lena Hidalgo, who will be here later.
Troy McKinney, representing the criminal defense lawyers.
Thank you, everyone. A number of us have been serving side by side on this board for a number of years. My name is Judge Angela Rodriguez. I'm Justice of the Peace, representing the JP Courts, Justice of the Peace Courts, otherwise known as Justice Court. I'd like to remind everyone that we will have order and decorum, as always, and if you will please be kind to the record keepers. If you're going to be participating in the discussion, make sure that you mention your name so that we can keep the record straight. We have reading of prior minutes. Did we
Chair,
have-
I would make a motion that we accept the minutes as posted.
Do I hear a second?
Second.
Does anyone have any discussion? Thank you.
Everyone in favor?
All in favor signify by saying aye.
Aye.
Any nays? The ayes have it, approved. There is no old business that I'm aware of. Moving on to new business. Notice of results of the election for Harris County Bail Bond Surety Representative for the remainder of 2022. Sheriff Gonzalez,
Thank you, Madam Chair. We have the following inspections that were done and completed by our team.
we have an election of the Bail Bond Board representative, and we had a number of candidates involved. And at this time, I will ask the sheriff's office to be able to address the results of that election.
Thank you, Madam Chair. This letter is to notify you that the elected bail bondsman representative for the remainder of 2022 is Agent Mario Garza with Bankers Insurance Company, DBA First Advantage Bail Bonds, license number 74485. This was submitted by Sergeant Sisto de Leon with the Harris County Sheriff's Office.
Thank you very much, Sheriff. We do have a new representative of the Bail Bond Board recently elected. Thank you.
If it is president, you can take a chair up there.
Yeah.
Sure. Would you like to join us? No. Okay. Okay. It's my understanding that we do not have to swear this gentleman in, so we have an opinion on that? He has it. I do have language if you want us to swear him in, but we haven't done that in the past. Thank you. The answer is no, ladies and gentlemen, so we're going to move on. Moving swiftly along to the business of the day. We have C2. Thank you so much, Judge. Request for renewal of license. We have Tamika Bowen, Wadire Incomplete, DBA Bowen's Bail Bonds, license number 74490, 2323 Ellis School Road, Baytown, Texas, 77521, original date, March the 11th, 2008, expiration date, March the 21st, 2022, phone number 281-426-5577, and this is for a 3-year license renewal. Ma'am, could you please raise your right hand to be sworn, both of you, if you will?
I'm not going to be sworn. I won't be sworn, Your Honor.
Thank you.
Aye.
We won't swear you in today, sir. Do you swear that your testimony before the Harris County Bail Bond Board to be the truth, the whole truth, and nothing but the truth?
I do.
State your name for the record, please.
Tamika Bowen.
Thank you.
And Your Honor, may it please the court?
Yes, sir.
I'm here representing Ms. Bowen. My name is Mike Monks. And I indicated to her that all these people were not here to see her license.
They're here to see you, right?
No.
Very well. Actually, a few months ago, we had very few people at the meeting, and that's one of the last meetings that our former chair chaired, and it was quite brief, I must say. Notable, very brief. It might have actually made a world record. We don't know for sure. Nevertheless, do we have any discussion? Starting with Sheriff Gonzalez, please.
Thank you, Madam Chair. The Harris County Sheriff's Office did inspect this request, Bowen's Bail Bonds, Tamika Bowen, license number 74490. An inspection was done of the property. All files inspected were in compliance. Bowen's Bail Bonds is a cash license. She currently has $50,000 deposited with the Treasurer's Office. The bonding license is currently in ratio, and we know of no past due unpaid judgments owed to Harris County as of 3/8 of 2022, and no other comments on this application.
Okay. Do you have any discussion on this?
No questions.
Questions? Sir, do you have any discussion or questions on this item?
None.
Judge?
Have none.
I've reviewed the application, everything's complete, no unpaid judgments, so no questions.
Nothing from me. Judge?
Judge Martin, no questions.
Judge Baldwin, no questions.
Wes McCoy, no questions.
Catherine Case, no questions.
Troy McKinney, no questions.
Michael Butera, I'll make a motion to approve.
Chair will entertain a motion.
Sorry.
Second.
Thank you. Seconded by our sheriff. Any further discussion? Any public comment on this item? Thank you. All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. Congratulations.
Thank you, Madam Chairman.
On to item C3. Going to 3, request for new license. North River Insurance Company, while diaring complete. Agent Rebecca Williams Tate, license number to be determined. DBA 000 McKnight's Bail Bonds, 6826 West Montgomery Road, Houston, Texas 77091. Phone number 713-713-3551. A 2-year license. Ma'am, could you please raise your right hand? Thank you. Do you swear that your testimony before the Harris County Bail Bond Board to be the truth, the whole truth, and nothing but the truth?
I do.
Ma'am, could you please state your name for the record?
Rebecca Williams Tate.
Okay, we'll have any discussion, starting with Sheriff, when you're ready.
Yes. Thank you, Madam Chair. The Sheriff's Office did conduct an inspection or review of this file. Rebecca, is it Rebecca?
Rebecca.
Okay, Rebecca is the daughter of Esther Williams, who passed recently. So on behalf of the Bail Bond Board and the Harris County Sheriff's Office, we want to extend our condolences to you and your family. Regarding the application, an inspection of the property has been completed and all was in compliance. The application is found to be complete. We do have just a question regarding the runoff of Esther's license. And can you please explain your plan moving forward? So I don't know if that would be.
My name is Mike Padilla. I'm the Vice President of North River Insurance Company. Rebecca is going to be effectuating the runoff of the previous business owned by her mother as well.
And no other comments on this application, Madam Chair.
Thank you so much. Do you have any discussion?
No question.
Sir?
Mario Garza, no questions.
Okay, Judge?
Judge Marshall, no questions.
Your application is complete. I don't have any questions, but I do want to extend my sympathy as well on the loss of your mother. Both of our new licenses on this agenda are from unfortunate, passings. So best of luck to you.
Thank you. Thank you. I couldn't have said it better. I don't have any questions for you, ma'am.
Judge Martin, no questions. Judge Baldwin, my condolences, but no questions.
Wes McCoy, no questions.
Catherine Case, no questions.
Troy McKinney, no questions.
Any further discussion? Any public comment on this item? Hearing none. And by the way, to the audience, if you have any comment on any item that is under discussion at the moment, if you get my attention, you will be recognized. I believe we do have an order of how to take the public comments, and there may be some more public comments on another item or a couple of items moving forward. The chair will entertain a motion.
Troy McKinney, move to approve.
I'll second.
Thank you. Council McKinney moves to approve. Ms. Case seconds. Council Case seconds. All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Approved. Congratulations.
Thank you, Board.
Thank you. On to number 4. Request for new license. Allegheny Casualty Company, Waudire, incomplete. Agent, Christopher Strickland. License number to be determined. DBA A1 Bonding Company 2, 4801 Katy Freeway. Phone number 713-759-0000. Houston, Texas 77007. 2-year license. Mr. Strickland, would you please raise your right hand to be sworn? Mr. Strickland, do you swear that your testimony before the Harris County Bail Bond Board to be the truth, the whole truth, and nothing but the truth?
I do.
Sir, please state your name for the record.
Christopher David Strickland.
Kim Good, I'm here as attorney for Allegheny, and I'm also assistant secretary, so I'm the corporate rep as well.
Thank you, Mr. Good. I extend my condolences for your father. We served next to him for a number of years. He's an honorable man, and
It was a pleasure
We
and
miss
honor
him.
for him to serve on this court.
we miss him, and he enjoyed it very much.
Yes, he did.
We refer to Chris as Glenn 2.0, especially from back.
Thank you.
Thank you for being here. It's good to see you.
Thank you.
Now, do we have any discussion, Sheriff?
Thank you, Madam Chair. Similar to the last application, it's a similar circumstance. Christopher, as we know, is the son of Glenn Strickland, who served as the chairman of the board of this bail bond board until his sudden passing. And so, Chris, on behalf of the bail bond board, as the judge extended condolences, we too want to extend our condolences on behalf of the board and also the Harris County Sheriff's Office. So please extend that to the rest of the family.
Thank you.
Regarding the application, an inspection of the property has been completed. All was in compliance. The application is found to be complete, and Allegheny has submitted a letter to the board. And could you please summarize the plan, just so we can make sure we have that on the record?
Yes, so our runoff plan for this license is the files, as you know, have to stay in the county. They will stay right where they are right now. And Chris, the former employees for Glenn Strickland are, most of them are staying with Chris Strickland, if not all of them. And so if you call this number, after this license approved and we post the CD and 10 days passes, and he will be able to start writing bonds. He's continued to answer phone calls, get notices to court, people, and he will continue to do that for the existing open liability, which is about $2.5 million for the Allegheny license and another $2.5 million for the international license, for a total of around $4 or $5 million. Which and so he will continue to run that off with the assistance of Glenn's wife. And but from your standpoint, the files will continue where they're currently located, where they've been located, and the phone numbers will remain the same. Thank you.
Thank you for the update. No other comments on this application.
Thank
Madam
you.
Chair.
Thank you. As is any other item, we're going to go one by one for any discussion. So do you have any discussion, sir?
No questions?
Okay.
Mario Garza, no questions.
Judge Marshall, my condolences, no questions.
Nothing from the DA's office.
Go ahead.
Judge Martin, no questions.
Judge Baldwin, no questions.
Wes McCoy, no questions.
Catherine Case, no questions.
Troy McKinney, no questions.
Thank you, everyone. The chair will entertain a motion.
So moved.
Second, McKinney.
All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? It's unanimous. The ayes have it. Congratulations, Mr. Strickland.
Thank you very much.
Thank you very much.
Thank you, Mr. Good. I see we have, let's see, 3 more items on the agenda. Number 5, discuss and consider adding subsection A to Bail Bond Board Rule 12 in relation to the adoption of procedures and time limits for public comments as follows. Section A. Anyone wishing to speak at any Bail Bond Board meeting with respect to any issue or any item on the Bail Bond Board agenda is limited to 3 minutes, exclusive of any time spent answering specific questions by any member of the board. The board may make and approve a motion to extend the time for any speaker. We will have any discussion or questions, starting with Sheriff.
No comment. No question.
I will say, I think this is a good rule. I think we should probably go a step further with more formal rules of how we conduct our business. Just for an example, to formally adopt Robert's rules. But I think this is a great rule to get us started in the right direction.
Mario Garza, I agree that this is a good rule to start with for now.
Thank you. Judge?
No objections or questions right now.
Michael Butera from the DA's office. I think it's a great idea just to ask people to, be thoughtful in their comments and limit their time for necessary purposes. But I would point out, I think if we're going to adopt a new rule, we have a 10-day posting period for the actual adoption. I don't know that at that meeting, that this meeting, that necessarily constrains us from, I'm sure we'll have many speakers asking our speakers to be thoughtful and non-repetitive and thoughtful of everyone else who is here, to take time and know that other people want to speak. But I don't know that we could adopt and enforce the rule at this meeting, based on the 10-day posting requirement. That's just my thought.
Thank you. And I'm inclined to see that as more of a standard, at least, for the rest of the agenda today, given the circumstances and the complexity of what is on the agenda and the timeline by which it was posted and placed and noticed. Judge?
Judge Martin, no comments or questions.
Judge Baldwin, no comments or questions?
Wes McCoy, no questions at this time.
Catherine Case, no questions at this time.
No comments from McKinney,
Thank you.
other than to move that we pass it.
Okay. Well, we're about to make a motion to pass it. We have some discussion. Do we have any public comment? Okay. What is the board's pleasure?
I move that we adopt the resolution item 5.
One moment, I just have a couple of things to say, if you will. Regarding the discussion, it seems that there are some general concerns as to the length of time that has passed between putting this on our agenda and considering it. And perhaps the same would be applicable to the other agenda item, but we'll address this item at this time.
Just to clarify, I guess I don't have an objection to the item at all. I think it's a good item to add to our rules. I was referring to the rule that the board has to post a change to the local rules for at least 10 days before it takes effect. But I certainly support Troy's motion. I would second it, actually. Just with the comment that we worked so hard on the local rules. I know Troy feels my pain on that. He and I and another employee from our office, Morgan Navarro, worked so hard. I hate to add a subpoint A to Rule 12 because it doesn't have an AB. Maybe if we could just add it as a new paragraph to Rule 12. That's a very minor thing.
I'm perfectly fine with the.
We put in so much
paragraph.
time getting it squared away. So I would second the motion, support it. I just was bringing up that it needs to be posted for 10 days before it's fully in effect, but I do think we can informally, as not part of the rules, ask, the participants here today to limit their comments in a reasonable way to let everyone be heard. That was my only comment.
Thank you. Well, today, everyone will be heard. That is a very important aspect of our board. And moving to Council McKinney, did you have a motion?
Michael, do you have the rules in front of you?
I do, yes.
What would be the next, well, I guess the next would be 19, since that's what's on item 7, but, yeah.
You mean at the end, Troy?
Yeah.
What's the last rule? Yeah, so our current final rule is Rule 18. I think perhaps it was added as part of Rule 12 because that rule addresses the Open Meetings Act and various other relevant things. So we could either maybe title Rule 12, meeting procedure or meeting, something like that, make this current paragraph subparagraph A and then make the existing change if it passes subparagraph B.
Then I move that we do that.
Okay. And I'll second that motion.
Thank you. Any further discussion? Thank you. All in favor signify by saying aye. One moment. Did you amend it at all, or is it just as written?
We amended not the text of the rule, Judge, but if I'm correct, Troy, correct me if I'm wrong, we were going to entitle Rule 12 Meeting Procedures, take the current paragraph, the only existing paragraph in Rule 12 and make it A, and then make this rule on the agenda Rule B, or subpart 12B. But there's no substantive change to the text of the rule.
That is correct.
Okay, thank you. I just wanted to make sure there was no significant amendments. All those in favor signify by saying aye.
Aye.
All those opposed? The ayes have it. Motion carries, and it is approved. We have 6 and 7 left on our agenda. Item number 6. Welcome, Judge Hidalgo.
Thank you so much.
And may the record reflect that Judge Hidalgo is present. Item 6. Request for discussion and potential action regarding bail bond security premiums and a requirement that bonding companies collect a minimum percentage of bail before posting a surety bond. Consider meeting in an executive session for legal advice regarding this issue. Well, we can start by discussing. It's my understanding that we will start with discussion and then move on from there. Starting,
I
yes.
would request an executive session
Okay, thank you.
regarding this. I think there's exact language, I don't know what it is.
I see, one moment. Okay. Judge requests an executive session on this matter. Does anyone have any other thoughts regarding tabling this for a month so we can look at the specifics of this?
Mario Garza, the bondsman rep. I'd like to make a motion for the DA's office to request an attorney general opinion regarding this matter before we go into an executive session.
Okay. Well, this is really, it goes under the line of discussion.
We need.
Yes, sir.
Tommy's help.
Thank you.
Sorry, before we take any action or consider any action, it may be a good idea to take public comment on the item.
Thank you, thank you. Yes, ma'am.
Thank you.
The chair recognizes Judge Delgado. Yes, ma'am. Judge Hidalgo, I'm so sorry.
I'd like to make remarks. Is that appropriate?
We will get to that in just a little bit.
Okay, thank you.
Okay. I'm going to go ahead and start by repeating the item so everyone can get their thoughts together. Item number 6 of 7 items on the agenda. Request for discussion and potential action regarding bail bond surety premiums and a requirement that bonding companies collect a minimum percentage of bail before posting a surety bond. Consider meeting in an executive session for legal advice regarding this issue. Now, I'd like to know what is the board's pleasure. We can consider voting on this issue today, or we can consider looking at the issue, discussing, have some public comment, and then having it on the agenda for next month. What is the board's pleasure? So we can have discussion on that, consideration on this agenda item, starting with Sheriff, please.
Thank you, Madam Chair. To me, I'd like to hear from the public. Obviously, they're here, and I want to hear their perspective on it. We did look at some information on this issue that I don't know if now would be the appropriate time to add that, or perhaps later. But I would like to first hear any questions and comments, and then make a decision on what's the next move based on the information we have.
Thank you. We do have a number of folks that are ready to speak on this agenda item, I believe, and we will get to them. Let's go ahead and ask. It's my understanding that we can go ahead and entertain public comment and still go ahead and make a decision as to what to do with this item. Is that correct?
I'm sorry, say that again.
Since we have certain individuals present to speak on this as a public comment, I'm inclined to allow them to give public comment. And then if we decide to address this issue perhaps next month as a tabling matter, then we can come back again and readdress that. But I don't want to silence anyone today that has taken the time out of their schedules to come.
No, that's fine, Judge. So what you can do is you can open it up for public comment, and individuals can come and make their statements, and after that, you all decide what you want to do by motion, right? If you want to take it back to executive session, that's something the body can decide to do. If you want to table it, you can do that as well. If you want to vote on any other motion, as one of the board members mentioned, you can do that as well. But typically, you would have the open comment, and then you can decide by motion what you want to do.
Thank you. What we'll go ahead and do is we'll go through the board quickly, and then we'll have our public comment, and then readdress the board in discussion, and then make a decision as to what we're going to do. Whatever the board's pleasure is. So if you'd like to make some quick statements.
Oh, I'm sorry, go ahead.
Thank you, Madam Chair. Just a couple things. I do want to say that the sheriff's, that our team did do a spot check on some of the bonding companies to view records of some of the larger bonds that are posted. Our findings show that most bonding companies charge an average of 8 to 10% as a premium charge. However, there are some that take as little as 2% down and place the client on a payment plan for the rest. I just wanted to kind of tee it up on what we saw in terms of our data. More broadly, I also want to say that this is a very important topic. You know, I know that there's a lot of concerns about crime and reoffending and what have you, and those type of issues. I just want to say globally that, just to manage expectations, that there's a lot of issues that probably need to be addressed in the entire criminal justice system. Not only the posting of a bond or how much that is, that's going to be very critical. That's important, but we also need a lot of other improvements in the entire process in terms of managing risk. That has to be a top priority, and I think we have to look at those issues as well beyond the scope of this particular board. But I just wanted kind of, for those in attendance, to know that we've got to tackle all these issues together, and this is an important one as well. We do need to make sure that we strike the right balance, and that we do our homework, and that we have thoughtful discussion about this. But I just want to just lay that as a foundational comment. No more comments.
Thank you.
Does anyone object to going ahead and having those who are waiting to give public comment come up at this time, and then we can take up discussion by the board, since we do seem to have a number of people who want to speak?
I'll make a
Judge.
motion to first hear from the public speakers, and then we could begin discussion.
I second
Okay.
that.
Actually, what the approach was a sandwich approach. I don't want to be quoted as a sandwich approach. But we start our preliminary discussion, and then we hear our public comment, and then we will have another opportunity for the board to address it, and I will recognize each board member. So that if you have any opening comments, you can feel free to do so at this time. So instead of going through the rest of the board, does anyone else have any opening comments that they would like to share before we go to the public comments?
No. And I think we have a motion and a second to start with public comment, Judge.
I do have a comment. Is that what you're asking, if
Yes.
anybody has a comment? And I just to this point of perhaps tabling the discussion to later, and I want to air this out just because I suspect some of the speakers may have a perspective on this, so I make this comment for the benefit of folks who are here, and I appreciate everybody who's taken the time to join us. And that is, you know, as all of us know, we're facing a gun violence epidemic, not just in Harris County particularly, in Texas, but around the nation. And it's an urgent issue, and I'm alarmed at the suggestion that we push this off. I think to Sheriff Gonzalez's point, and I know we had this discussion at Commissioner's Court when you joined us a couple of weeks ago, there's a lot of players in this system, and everybody has to do their part. And we have an opportunity today to fix a part of the system that is not working adequately because it's undercutting judges when they make decisions to set high bond amounts for people who should not be out free. There has been a dashboard published. There's been plenty of news reports on it, and it's publicly available, that has shown that the bond amounts set by judges compared to 2017 have gone up dramatically. But as you hear from the sheriff, and we've discussed this at Commissioner's Court in the past with the representative from the bail bond industry, there are some actors, and I don't want to cast a broad brush here, but there are some actors that are setting bond amounts, deliberately undercutting high bail amounts set by judges who have been, unfortunately, made scapegoats for violent crime. And so I don't think we can, in good conscience, support a part of a system that is putting profits over public safety, and we don't have time to continue extending this. I know that there has been plenty of notice that the discussion was going to take place today. It's been discussed in public several times at Commissioner's Court. There has been a meeting of this board between then and now. Certainly the public is aware that the discussion was going to take place today and the vote was going to take place today. So
Thank you, Judge.
I would like to make sure that we vote to make it harder for certain bail bond agents to act deceptively and to make sure that we keep violent criminals behind bars, particularly during this crime wave.
Do you have anything else for your opening comment?
No, I'm grateful that everybody's here. Thank you, Judge.
Thank you, everyone. I believe it is the board's pleasure to proceed with public comment, so we will begin so at this time. Does anyone have any public comment? I believe we have a list. Just make sure that I'm aware of the list. Welcome, Commissioner. It's my understanding we're starting with about 3 minutes, everyone.
Thank you.
Whenever you're ready, sir.
Thank you, Madam Chair and members of the board, and in particular, Treasurer Osborne. I want to thank you for placing this item on today's agenda for the board to decide whether freedom of violent and dangerous individuals will be easily obtained or not. I also want to recognize some of my fellow elected officials community leaders in attendance. Commissioner Ellis will be here for Mayor Turner. Bill Kelly will be here be here as well. Rather, Commissioner Ellis will join us, and then Bill Kelly will join us for Mayor Turner, and then Chief Fenner will be represented by Assistant Chief Matt Slinkard. I also want to recognize Mr. Paul Castro. I'll let Mr. Castro tell his story when he's recognized to testify. But Mr. Castro, your advocacy of the tragedy that befell your family, as well as other surviving members whose loved ones were victims of violence, collectively created a chain of events that brings us here today. How you all have been able to show the tremendous courage in channeling your sadness to make a difference is one of the most amazing and inspiring things I have witnessed in my life. And I'm hopeful that the elected officials here today will stand with you and your loved ones. When I came to speak to this board last month, I shared the feelings of a bipartisan group of all 5 members of Commissioners Court who voted unanimously to pass a resolution calling for a 10% to be the standard minimum amount to be put down for a bondsman to bail someone out accused of violent crimes. And the City of Houston is aligned with Harris County on this through their One Safe Houston program, as well as a proposed ordinance that they're bringing forward. I'm here again today to urge you to be courageous, to do the right thing. This is not about politics, but this is about the families who are impacted by this. When someone is accused of a violent crime, but is able to be bailed out of jail for 1-2%, that puts the loved ones, the loved ones of the victims in a state of fear. In fact, I just heard about some of those stories before I walked in here today by Ms. Machado. These families
You'll be given a 15-second warning for the time.
These families are already suffered a loss. They should be advocating for their safety because they are the ones who have to live their lives wondering whether or not their loved one's accused assailant is out on the street on a discount. We must all do our part to protect the victims of crime and keep their families safe. Standards are set for a reason, and when a judge does their duty by setting a high bail, as an example, $1 million bail, but it takes only 1 to 2% to get someone out, then what does that $1 million bond really mean? This standard needs to become a requirement that will ensure that others across the state will also follow. Enforcing a 10% standard is a no-brainer and will put you all on the right side of history. Enforcing the standard is a commitment to protect victims and their families of crime and keep their neighborhoods safe as well. This is urgent. Victims of violence are counting on us all. Thank you.
Thank you very much, Commissioner. We're going to go ahead and go on to the next public speaker. And if you have any applause, if you could just wait until everyone has done addressing what they have to say regarding any item. Okay. As we know, bail bonds and an issue of bail bonds is related to criminal law. And when it's related to criminal law, you're talking about crimes. And crimes range from jaywalking all the way up to the top. So the rules that we set in the bail bond board are applicable to everyone in every situation. So that's what we're going to go ahead and listen to. Could you please, who else has a public comment? If you could address it by raising your hand.
Is there a list?
I don't think there's a list, so we're going to go ahead and move forward one by one. The gentleman with the red tie, if you could be next, thank you. You have about 3 minutes, and with a 15-second warning that you will be given.
Thank you, Madam Chair and member of the board and presiding Judge Marshall. My name is Bill Kelly. I'm the Director of Government Relations for Houston Mayor Sylvester Turner. The mayor asked me to read a letter on his behalf today to the board concerning the current resolution before the bail bond board. The city of Houston, like most major cities across the country, has experienced an increase in crime. There are no easy answers or singular initiatives standing by itself that adequately addresses this trend. It requires a holistic and comprehensive strategy, as Sheriff Gonzalez noted. On February 2nd, Mayor Turner introduced the One Safe Houston initiative to combat the uptick in violent crimes across our city. As part of that plan, he outlined several efforts that require collaboration with stakeholders, community and faith-based leaders, businesses, law enforcement agencies across the region. The criminal justice system plays a critical role in upholding public safety. We must acknowledge when inefficiencies of that system threaten public safety here in Harris County. The One Safe Houston initiative identifies actions under the bond company protocols and best practices section that addresses an alarming practice of bail bond companies. Bail bonding companies that are in some instances now requiring substantially less than the customary 10% premium required to post bond. Mayor Turner has instructed the city legal department to draft an ordinance for consideration by Houston City Council, which would require that bail bond companies charge a premium which is equal to at least 10% of the amount of bail bond set by the court. This would require that the cost of the bail bond be equal to that of what the public generally believes to be the cost of a bond rather than a lesser amount. Mayor Turner today strongly supports the adoption of regulations by the Harris County Bail Bond Board requiring that all companies issuing bonds within Harris County charge a premium equal to at least 10% of the amount of the bond. If the Bail Bond Board were to adopt such a standard for the entire county, the city would consider it unnecessary to move forward with the passage of a proposed ordinance. Otherwise, the city will act. It is understandable that many in our community are frightened and outraged by the increase in violent crime and the release of criminals on lower than a 10% minimum bond. Every Houstonian deserves to feel safe in our region. Again, Mayor Turner urges the swift adoption of regulations requiring that all companies issuing bonds within Harris County charge a premium equal to or at least 10% of the amount of the bond. The mayor feels confident that if we work collaboratively and expeditiously, the Houston-Harris County region will reduce violence and return to a safe place to live, work, and raise a family. With that, I'd also like to indicate Executive Chief Matt Slinkard is here for the support of the Houston Police Department for this resolution as well, and offer him for any subject matter expertise. But again, thank you, and thank you to the elected officials who've been cooperative in our conversations in creating our One Safe Houston plan. I have a copy of the letter that I can distribute to all members of the board, and happy to take any questions that you might have.
You can go ahead and give it to him. Thank you. Thank you for your words.
Bill, thank you for coming down today. It's nice to see you again. With you and Chris Banks in the back of the room sitting next to Ed Gonzalez, I feel like I'm back at a city council committee meeting. It's kind of nice. But thank you for coming, and thank you to the mayor for his remarks.
I think we both had more hair back then in those committee meetings, for sure. Thank you.
Thank you, sir. Okay. Okay, if everyone could make room for the people that are coming to do public comments. The next person for public comment, sir, are you raising your hand?
I can.
Okay, sir, I'm going to go ahead and address him first.
Sorry.
Thank you. I appreciate the enthusiasm. And I'd like to thank everyone here for contributing to the order of this honorable board meeting.
Thank you. Good afternoon. My name is Paul Castro. I'm the father of David Castro, who was murdered July 6th of last year. With tips from our community, Houston PD was able to find and arrest the killer in just 4 weeks. The killer was a 2-time violent felon who had not even been out of prison for a full year before he killed my son. A month after his arrest, David's killer was released on bond. Though the judge set the case bond at $350,000, nobody knows how much was actually paid for him to be released. Traditionally, he would have had to have come up with $35,000 to make bond, an amount that probably would have been high enough to keep him in jail today. He is not in jail today. Because of the gap in bail bond policy, he is free on less than $35,000. His bondsman is known for accepting amounts as low as 2%. 2%. My son's life was traded for $7,000. Today, I speak out on the justice system to anyone who will listen. I ask them, what do you know about bond? And they generally don't know very much, but one thing they all say is, well, it takes 10% to be put out on bond. When I tell them they're wrong, they are furious. Today I stand here as a speaker. I want to thank the Alvarez family for joining us. I know there are others who are here. And we stand and speak with one voice. And we're asking you to fix the wrong. A small group of bond companies, not all of them, many are run by the same family. They take advantage of this policy, and they make money on other people's pain. It is unethical. A report by ABC 13 found that in the last 5 years, there were 968 accused felons who posted bond and were later arrested, not for one, not for two, not for three, but for 4 or more other violent offenses. The victims of those repeat offenders are here with me asking for your protection. Fixing a broken criminal justice system will require many changes at many levels. That's already been stated today. The people have already begun speaking out. They've identified judges who were not tough on crime, who did not protect our community. That was just the first step. You have the next step. Some of you might object to this change, saying the board does not have this jurisdiction. I ask you to be courageous and take a bold stand for our community. Halfway across the globe, a demonstration of true leadership, Ukrainian President Volodymyr Zelensky is standing up for his people and risking his life. I'm asking you to stand up for our community and stand up to the bad actors in the bond community. All you're risking is a lawsuit. Refusing to fix this problem is not acceptable. When you do fix the problem, the DA and judges will be able to set bonds that are understandable by not just us, but the community. Please do your duty. Vote to approve this policy change. Do it for my son David and all the other families who are here today. Thank you.
Next speaker, please. Thank you for your words, sir. Would anyone who would like to participate in a public comment on this issue can raise their right hand? Okay. We'll take the gentleman in the brown and then the lady in the red shirt.
Thank you for your service on the board. My name is Rodney Vanderson. I'm a license holder, a bondsman here in the county. From an industry standpoint, we too believe that there are major changes needed to correct these issues. To the families who have lost their loved ones, grief is felt by all. As I look at the language, you know, there's going to be others that argue the merit as to what can and cannot be done legally. I'm not versed in that, so I'm not going to address that. But as it's written here, there's a great emphasis on bondsmen and the corporate agents of bondsmen. We're not the only ones in this county that are licensed through this board. There's no mention of the attorneys who can post bond. Section 162 of Occupations Code, 1704-162, I believe, provides an exemption to attorneys. They too charge a premium for the services of bonding somebody out of custody. They can do so for their own clients. I see no reference to controlling the behaviors or fixing the minimum prices that they can charge for the bonds that they post. And I see that as a very troublesome potential liability in some kind of an unfair trade practice inadvertently being created. So I want to bring that to your attention. Secondly, there is what I would feel to be a great hypocrisy in the focus on the money and what we as private business owners charge for our services, and the complete abandonment of PR bonds and the collections. It's my understanding in the district clerk's office, there are hundreds of millions of dollars worth of uncollected PR bonds. There's never been a lawsuit for collection that I'm aware of or that I could find any evidence of. And so if you're going to make money a focus in who's making what, why not make it an even playing field and start following up on the collection for those people who haven't made their appearances as they promised the court they would under their own personal recognizance. Thank you very much.
Thank you for your comments. We will go ahead and take the next public comment. Ma'am, welcome.
My name is Blanca Mejia. I am the aunt of Diamond Alvarez. I am here today with my family because we don't want to wait for the predator to be a repeated offender, to be able to fit the criteria of this bail reform. The bail reform is made for low-budget offenders, apparently, yet there are no low-budget offenses. When you commit a murder, you commit a murder. Why do they have that possibility to be let out on a minimum amount of bail? I think it's unfair. My family has been harassed, threatened continuously since January 11th, since this happened. They've been ran off from the field. They've been harassing their homes. It's not just Diamond's family that lives in that neighborhood. We have plenty of family in that neighborhood, and I think it's unfair that this man is out free because he lives there. His friends, which we already have 3 incidents that have been reported, yet nothing has been done. This man is still free. There's been a couple of gentlemen that are in jail for retaliation. So if there's retaliation, if there's a connection, why have they not revoked his bond? Why is he still free? It's important that we bring safety to my family because they can't sleep at night. They don't sleep. They have to stay up looking at these cameras because they're being harassed. So we want to know what we can do so this man is not filling that criteria. We don't want to wait until he's a repeated offender. What happens to those people that are not repeated offenders, that continuously be harassing us? It's unfair. It's unfair for my family. It's unfair for everybody in the neighborhood. Everybody's at risk with this killer in the neighborhood. It's really unfair. Thank you.
Thank you. The gentleman with the black shirt from Fiel. Welcome.
Yes, good afternoon. My name is Cesar Espinosa, and I'm Executive Director of Fiel. Before, I start my main remarks, I do want to acknowledge the families that are here, starting with David Castro's family, Mr. Paul Castro, Diamond Alvarez family, Arlene Alvarez family, as well as Martha Medina's families, who are all families who have, in one way, suffered because of our broken criminal justice system. I did want to put some context behind it and the fact that we understand, and the families are slowly understanding, that sometimes justice is a very slow-moving process, and in terms of they have to wait. But we, at the forefront, have to keep these families in mind and know that they've already suffered a huge tragedy, and we don't want to be responsible for them suffering another tragedy internally or externally, or having another member of our community face these tragedies. We know that this issue is going to be complex. We ask that people continue to support and uplift these families, because at the end of the day, they are the ones that are having to deal with every single day struggles of missing their loved ones. And really, our condolences go out to you all, and our respect goes out to you all for taking the courage to do this. We want to make sure that just as the community is held at a standard, that we hold everybody at a standard, including the Bells Bonds Company, who in a lot of ways are responsible for making profit out of people who have committed crimes. And we want, every time you mix money into the issue or a lack thereof, then that's where the issues arise. We stand with the community, but at the same time, we request that this is dealt with immediately, so that we don't have to comfort another family because of the loss of their loved one. We in the past have mainly focused on immigration issues, but given the fact that crime has erupted all over the nation, not only here in Houston, but all over the place, we're now being tasked by families to come and support them, and that's why we're here. But I want to make sure that we uplift these families, and thank you, Sheriff Gonzalez, for making sure that they are heard, because many of these families have their life has been thrown into disarray because of the different things that have happened. So I want to thank every single one of you for being here. Thank you.
Thank you for your words. Okay, we're going to take another public comment. Sir?
Thank you. I'm Executive Chief Matt Slinkard with the Houston Police Department, and I felt it was necessary to come today on behalf of Chief Fenner, who couldn't be with us, and all of the 5,200 men and women of the Houston Police Department to share some comments with the board. I want to thank all of the honorable board members for your time and your attention in listening to such an important issue. And I cannot speak for these families any better than they can for themselves. And so what I'd like to do today is just to speak from a law enforcement perspective, and from a law enforcement subject matter expert perspective, and some of the things that I heard today, and thank you for your comments from our leaders. From Sheriff Gonzalez, we need improvements throughout the entire system, some thoughtful discussion. Correct, I agree, sir. From Judge Hidalgo, thank you so much. Let's be careful not to place profits over public safety, was one of your comments. From Commissioner Garcia, thank you so much. Your comment was about being courageous and doing the right thing. And so I think we can see that we all as community leaders and we all as servants to the public, we all have our heart and our spirit in the right place. And we work in agencies and work with men and women who dedicate their life to public service and do a phenomenal job every single day. But the fact remains, where we are today and where we are in our county and where we are in our nation, we are facing some unique challenges that we haven't faced in the past. And those unique challenges, I think, are going to require us to come forward with some unique and creative solutions to make sure that we are doing everything possible to keep our community safe. You know, I appreciate Mr. Kelly, the Director of Government Affairs for Mayor Turner, in coming and reading the mayor's letter, and I appreciate the mayor's efforts and heartfelt thoughts about this. And I'm not a bail bonds expert, but I know that we far too often are meeting with families that feel re-victimized when offenders have been released on what would seemingly be something that none of us would agree is likely a best practice or protocol. And I think if we could focus our discussions around what is our best practice and protocol going forward, how can we do our best to follow the Constitution and the laws and come up with a system where we are taking risk into account and we are making sure that we are fair and equitable, but fair and equitable as well to the victims of these crimes. And so the men and women of HPD, obviously the largest law enforcement agency in the state of Texas, we are out there every single day. We will continue to be, to do everything possible. You know, but I want to remind this board, oftentimes when we make notifications to family members that have suffered a tragedy, keep in mind it's not just us responding to the crime. It's often, I spent quite a bit of time with Mr. Castro, did we not? Speaking in those early days with other families in this room I've done too many press conferences over the loss of their loved ones. And oftentimes it's Chief Fenner or myself or other executives who are making the calls to those families that, hey, I have to give you some more tragic news. A low bond was reached and that individual's out for now, but we're still working with you to get you through this difficult time. And so I say, let's all come together. Let's put the talent and the heart and spirit of this region together and all of us to try to do the very best we can for the public. Thank you.
Thank you for your comments. Go ahead, sir.
Hello, my name's Sean Burns. I've been a bondsman for over 20 years. And I just want to say, one, I find it very interesting that we're here having this conversation because when the bail reform conversation began, the narrative that was told over and over again is that bondsmen cater to the rich and leave poor people in jail. I'm sure you'll all remember that. Now we've come full circle, and here we are saying we are no longer able to negotiate with the poor. We can only bond out those with money. Second of all, I just want to say I've yet to hear how this rule is going to make us any safer in Harris County. And I think we all agree that crime is through the roof. That's all I have to say.
Thank you, sir. Ma'am, go ahead.
Good afternoon. I'm Shannon Burns Pena. I'm the sister of Sean who just spoke. I'm like notorious for being a rule follower. On the way from the parking lot over here today, my brother heckled me a little bit for going to the crosswalk before crossing the street. He's like, oh, you know, of course you're not going to cross in the middle of the street. I love rules, but we don't need more rules when we already have rules in place to address these issues that we're concerned about. Commissioner Garcia mentioned an example of $1 million bond. Those don't get set, like bonds don't get set at $1 million. If the intent is to keep somebody in custody, let's set $1 million bond. As far as following rules, again, price fixing is not legal. So I don't see how we're gonna have the Harris County Bail Bond Board have authority over, you know, federal case law and the Texas Department of Insurance. That's it.
Thank you. Start time. Could you please state your name and continue?
Sure. My name is Ken Good. I'm an attorney specializing in Bella. I represent several insurance companies in Texas. I've appeared before you for many years. I just want to make a couple of comments. I've sent you all a long letter setting out a lot of arguments in detail. I just want to add a couple of arguments to that. I would just point out I've seen some language, and Judge Hidalgo pointed out that we have an incredible rise in gun violence, but if you look at the list of offenses that we're attempting to apply this rule to, I only see maybe a third of those offenses are gun-related. So if our intent is really gun violence, then we're overshooting through what the proposed language is. And the second argument I would make is, I know that you all have had a lot of discussion, or I assume that you've had a lot of discussion on, is this an issue that the board has the authority to enact a local rule on? And I've tried to summarize all the different cases and Attorney General's opinions, and I've divided them into three categories. The first category is where the board is enacting a local rule that addresses something else in the statute, because your authority to enact local rules is to implement the rest of the statute. Those are proper, but you still have to review other provisions. The best example is the Pruitt case, where y'all had the authority to act a local rule, because that was this board. But the board violated commercial speech, so it was still improper, even though you had the authority to enact it. And as a result, the county ended up paying $350,000 in attorney's fees for doing something it should not have done. The second category is when you change the law. Okay, we're not dealing with that, where you're adding something to licensing. And category 3 is where we're attempting to enact a local rule that doesn't address something else in the statute. I think this is a category 3 local rule and potentially a category 2, so it's the grayest area. But you still have to go to the second analysis. And I just want to point out these different arguments. In the Black case, which has been pointed out to you from the Dallas Court of Appeals, to support the authority you can enact a local rule, the Court of Appeals found the local rule improper because it violated separation of powers. I believe this local rule would violate separation of powers because you're adding a condition on the bond that the judge has not required, and also you're acting as the Texas legislature. If you want to set what we should charge, that should be done, if it can, at the Texas legislature, not here. The Texas Department of Insurance 20 years ago regulated what insurance companies charge for criminal appearance bonds. And the statute was amended and repealed so that it no longer applied to the regulation of criminal appearance bonds. The legislature did not give that authority to you or anyone else. I want to also talk about, this is really illegal price fixing. Think about it. We as an industry cannot get together and price fix. If we do, it is illegal. The Goldfarb case, which I believe has been provided to y'all, addresses price fixing involving an association under the Sherman Act. Texas has its own statute, the Texas Free Enterprise and Antitrust Act of 1983, which defines person to include anyone, any group, as long as it's not the state of Texas or a state agency.
I have a quick question for you. As you read what has been noticed in our agenda and proposed by one of our members, as you read it, would any change, because it doesn't mention a percentage in our agenda at this time, in the principal agenda, the standard of 10% has been mentioned in discussion, but as it is noticed today, do you believe that if we pass it as written, it would apply to all crimes, or it would apply to some crimes?
Oh, I think what I've seen language only applies to some crimes. If you look at just the language isn't clear because the language is just consider and possibly adopt. There's no proposed local rule set out in the agenda. Now, the language that I believe has been submitted to the board has a further problem because it talks about disclosure and affidavit and providing information for the dashboard. That's nowhere on the agenda, even as it's written.
That's a different item.
No, I don't believe it is. It's on the same, I think the proposed language is under this item on the agenda. There's no other item on the agenda that talks about disclosure or requiring disclosure of what we were paid so that it can be included on the dashboard. There's nothing on the agenda that authorizes that. So I think there's other things that this violates, our right to contract. We have a right to contract without interference by the government. We are a private industry. When we have all these complaints about if we do a payment plan, that somehow hurts. If that bond forfeits, we're going to pay the whole $1 million if they don't come back. And Michael Butera knows, we've paid $500,000, $750,000. If they don't come back timely, we have to pay the full amount, pay the full ticket. We don't pay what we were paid, we pay the full face amount of the bond.
But it's my understanding, if it's revoked, and it's different than forfeited.
But that's, your revoked bond is, yes, a bond is usually revoked because of a condition, a violation of a condition. The problem that we have is accountability here. If they're revoking a bond because of a condition violation, then they should be granted no bond instead of releasing them on a new bond. We guarantee appearance for court. We used to guarantee compliance with conditions as well. That the Constitution of Texas Constitution was amended to take that out. We guarantee appearance. We have the lowest failure to appear rate of any release mechanism. If you don't care whether people come to court, then you don't need us. If you want to get your case resolved quickest, the quickest way and the quickest release mechanism to use is us. And I mean, I just don't want that to be lost. And of all the release mechanisms out there, we're the only one that has the authority and the incentive to notify you, judges, that there's a problem with this person before forfeiture. And then after forfeiture, we have an incentive to go get them and bring them back to court, not issue a warrant to go down to the warrant division and wait to be served, wait for them to commit another crime. We go out looking for them.
Okay, thank you for
Thank you.
answering my question. Does anyone else have any quick questions for this gentleman before we move on to the next public comment? Do you have any questions, ma'am?
Madam Chair, I wonder if the county attorney could respond to some of the legal concerns that the gentleman raised, or if we do that later.
Oh, that's not going to happen during public
All right.
comment.
Thank you.
And
Thank you.
Judge,
Yes, sir.
if I may just add one point, the question that you asked about the sufficiency of the notice, under the Open Meetings Act, you just have to lay out the subject that's going to be discussed today. You don't have to put the specific text of the motion that you're going to make. You can make that motion from the table. This obviously encompasses any percentage amount that you all want to put in, any specific crime that you want to put in. You can modify that at the table, but sufficient notice has been provided.
Thank you, counsel. The purpose of my question was to forward the discussion, and in the interest of transparency and clarity, it seems to be that the prevailing percentage discussed has been 10%. And that's, the purpose of that was nothing more, nothing less, but to be clear.
No, just say you're fine under the law. That's all I'm saying.
Thank you.
And you've reviewed this, correct, county attorney, what has come?
Legal issue?
Correct.
Yeah, I have a whole presentation I'm going to give you all.
Thank you. We're going to go ahead and move on to the next public comment at this time. Yes, sir.
Thank you. Shelby Burns, local attorney. Just want to point out, 4 years ago, the vast majority of people out on bond in Harris County were out on surety bonds. Today, the vast majority are out on PR bonds or general order bonds, where they're released automatically if charged with certain misdemeanor offenses. And what's changed in those 4 years to make the crime rate go through the roof? It's not that there's been this big epidemic of bondsmen taking less down all of a sudden. It's this revolving door policy of not taking misdemeanors serious, automatic release, not getting their family involved at the time of release, which bail bondsmen do. What are we going to do in 2 years if we don't change these other revolving door policies and crime is still as bad as it is? Are we then going to look at 20% for bondsmen? This is scapegoating. Thank you.
Thank you, sir. Would anyone else have a public comment at this time? I do.
Good afternoon. My name is Carolina Tamayo. I wrote something down, and I think I'm here as a Christian to tell you guys exactly what's happening. And I think most of you already know. I'm not here to judge anybody or to condemn anyone for any reason. But this is what I'm here to tell you, what is going to happen to this city. And every city that does not have fear of the Lord, respect, that's what that means. We're going to see an overwhelming spirit of lawlessness take over. Our people will live in fear in this city. The lions, who are the police, You've removed their teeth, and the hyenas have no fear. And that is a quote from my son, who works in the detention center. He says, you've removed our teeth, the hyenas have no fear. So people like us, our children, citizens that are innocent are going to be in danger. Removing guns from people, from citizens who are law-abiding, is not going to solve the problem. Cain did not have a gun when he killed his brother Abel. So let that stay in your mind. You will cause the noble man to take justice into his own hands. And that is a prediction that is going to come true unless you guys take heed to what everyone is saying. We're not safe in this city, nor any other city that does not acknowledge God.
Do we have more folks who would like to contribute their public comment?
Madam Chair?
Yes, sir.
I'd be remiss as a former board member with Crime Stoppers if I see Andy Kahn in the audience. I'd like to see if he would like to offer any comments. I know they're an important stakeholder. Andy? No? Okay.
Yes, sir. Go ahead.
I'm Roger Moore. I'm an attorney. Been practicing law for about 40 years now, and about 30 of that has been in the bail bond world, and I'm here all around the state. So 2 points I want to make. First, to follow up with what Shelby Burns just talked about. There's nothing new about there being payment plans when a bond amount is fairly high. As I say, I represent clients all across the state, and they're everywhere. They particularly spiked after the 2008 recession because people were so tight on their money. Most bondsmen would prefer to get all of their fee up front, sure, and some of them are lousy about collecting what's owed to them. But this is not a new issue. What is new is the O'Donnell case in Harris County and the result of the revolving door practice that has occurred on the misdemeanor side. Second point, when a court sets bond, they're required to consider all the conditions that are in Article 1715. Now, one of those is safety of the community and the victim and law enforcement, and another is the ability to make bail. They then, after considering all of those factors and criminal history, beginning April 1st, they will then set an amount of bond, the form of bond, whether it's a personal or a surety bond, or in some rare circumstances, a full cash bond, and conditions, if any. And the courts are authorized to set any conditions necessary to protect victims or the community. The bondsmen do not enforce those conditions. Those are enforced by the court. The bondsmen make one promise, and that is that their defendant will be in court whenever they're required to be there. Adoption of a rule like you're talking about effectively sets another condition that would be tacked on to any bonds to which they apply. That is, you have to have a minimum fee, and one of the things that has been talked about is that all of that fee would have to be collected up front. I don't think this board or anybody other than the court has authority to set a condition on a bond. And so I agree with what Mr. Good talked about, it being a problem with the separation of powers. Finally, the legislature has had lots of opportunity to regulate what bondsmen charge, and they've simply chosen not to do so. As Mr. Good mentioned, at some time in the past, there were regulations that applied to insurance companies. There have never been regulations that applied to individual sureties who write bonds, what we call property bondsmen. But about 20 years ago, all of those went away, and the legislature did not give the authority to any other body. So again, I think that any attempt by this board to set a bond fee, whether it's 5%, 10, 20, or whatever, would be, again, a violation of the separation of powers and a usurpation of legislative authority. So the board ought to be very careful about moving into those areas that the board just doesn't have authority to act. Thank you.
Are you aware of any other county in the state that has such a decision made by a bail bond board?
No, Judge.
Okay.
There are no counties that have ever adopted such a rule or a policy, and in fact, I've never heard of a court that has attempted to set a minimum fee on a surety bond. That simply is left up to the marketplace, and when a bondsman writes a bond, they set their fee based upon their evaluation of risk. Some bonds, they're going to collect less than 10%. Some they may collect more. Some may want 100% of the face amount of the bond if they think it's a high-risk bond.
Could you quickly go over, just for clarity purposes, hardly anyone here is an expert in the intricacies of how to get a bond and how to keep a bond and everything. Sometimes what folks do is a family member is charged with a crime, and then they have a family meeting. And they'll say, what are we going to do about this? Let's make sure that all their rights are respected and get them a lawyer and see what's to be done. So hardly anyone is an expert in bonding. But could you go over quickly the difference between the things that courts do if someone violates the terms of a bond?
Sure. The bond itself,
Versus other things.
the bond itself is a promise to appear in court. So they can forfeit the bond if they miss a court appearance, and if they do not go back into custody within 6 months on a misdemeanor, 9 months on a felony, then the full amount of the bond is going to be due and payable to the state of Texas, paid over to Harris County in this case. If the court has set conditions of any kind, it might be a stay-away order for families. It might be a stay-away order from schools. It might be requiring regular urinalysis or drug testing. It might be installing an interlock device. It might be having a GPS monitor, ankle monitor, any number of conditions that the court might impose. If there's a violation, the court holds a hearing. If they find by a preponderance of the evidence, they revoke the bond. And at that point, a warrant is issued for the person's arrest, and they have to be picked back up and put back into custody and made to give a new bond. And presumably, the court would have more onerous conditions that they would set on any new bond. Okay?
Thank you for that. So there's basically not any one way that someone, once they violate the terms of their bond, there's a number of ways that courts will address it. And it's my understanding that some put liability on the bondman, and then other ways that are dealt, where an accused person violates the terms set by the court. And there are other ways where they show up later, whatnot, and then it doesn't give liability onto the bondsman.
That's right. Only a failure to appear when required to be physically present would create possible liability for the bondsman, because that's the only promise the bondsman makes, is to have them in court anytime the court says that they have to be there.
Okay, thank you. I know some people think there's just only one thing, but it's a little more complex than that. Thank you for that.
Any other
Thank you for
questions?
comments. Does anyone else have any other questions for this individual?
Thank you.
All right. I believe the gentleman closest to the microphone is the gentleman in the black jacket. Council McKinney.
Somebody had their hand up.
Okay, if the next person can come this way, thank you. Yes, sir.
Hi, I'm Andy Kahn, Director of Victim Services, Victim Advocacy, Crime Stoppers of Houston. I'm also a board member of Parents of Murdered Children and Surviving Family Members of Homicide, as well as Texas EquiSearch. And thank you, Mari, for attending our meetings. You've been attending for the last year. And again, we invite everybody to attend the Parents of Murdered Children's meetings and support all those who are survivors of homicide. We're part of a national organization. We have the largest active chapter in the country in Houston. We meet the second Tuesday of every month from 7 to 9 p.m., and I invite everybody to attend and support homicide survivors. One of the things I do want to bring up here is that last legislative session, we had a proposed constitutional amendment, and that constitutional amendment would have given judges discretion. It would have allowed voters to decide whether or not judges should have discretion, keyword discretion, not to grant bond to defendants charged with certain violent crimes, for example, like the defendant that is charged with the murder of Paul Castro's son, David. That bill failed. We saw no downside in giving Texas voters the ability to decide whether that was a good thing or a bad thing. So if next session, when I presume that that bill will be up again, I hope that this board and I hope that everybody here will support the efforts to give judges discretion. So, for example, if a judge says, well, I can give a $500,000 bond and hopefully they won't make it, but the point of what we're talking about today is some bond companies, very few, are giving very low bonds so they can make it. If that amendment would have passed, that would have allowed judges to say no bond based on the risk to public safety. Why it didn't pass is beyond my belief. I've been doing this for 30 years. I have never seen public safety become so partisan in my life. I do not understand that. When I go to the meetings of parents of murdered children and I look around the room, and it's the most diversified group that's attending, it's the only organization in which someone else writes out your membership for you. No one wants to be there. Sheriff Gonzalez, you have been there. Commissioner Garcia, you have been there as well. And it's time that we all come together. This is not a Republican issue. It's not a Democrat issue. It's not an independent issue. It is a public safety crisis issue. And none of the victims cared whether they were a D, an R, and an I. And we've got to start getting on the same plate together and address this issue. Thank you.
Okay, let's have the next few hands of the individuals who are intending to make a public comment. Do we have just one more person? Okay, we have two more. How many other people are going to make a public comment so that we can go ahead and? Okay, we have one, two. I'll make a second call. Anyone else? Third call. Do I see anyone else's hands? Okay, I see you. I see you, and I see you, gentlemen. Anyone else? The third call. Thank you. Third call. Final call. Thank you. We have two individuals that have raised their hands. The young lady with her phone. Ma'am, if you could just turn off your phone or put it on mute or whatever.
It's
go
on
ahead
mute.
and make your comment.
Yes, ma'am. I just have notes because sometimes I tend to black out. So
Please
that's
go
a
ahead
reason,
and-
I have my phone.
Absolutely.
So,
Go ahead and use your notes. Yes, ma'am.
I see a lot of everybody just pointing fingers. You got the bondsman pointing fingers to the judge. You got judges pointing fingers to the bonds. We need to figure this out. And fast. Because the crime rate right now is we never thought this was going to happen to us. I'm Arlene Alvarez's aunt. Never in a billion years that we thought that this was going to happen to us. And we do not recommend it to anybody, obviously, but
Take your time.
Some of you spoke about the risks of the public safety that the bond companies look at, right? In particular, in our case, this man checks off, that I know of, 4 out of 6. The severity of the alleged crime, he murdered my niece. My niece is in the grave. Any prior convictions, many dating back to 2007. If the defendant was on probation, I don't know, was he? I don't know that information, but that's a possible check, that he should have been checked as well. The defendant is a flight risk. We can't get an exact date of birth or valid ID on him. I don't know, is he? Is he a flight of risk? To me, it's a yes. Anybody is a flight to risk, a risk flight. The defendant is a risk to someone else's safety. Most definitely he is. My niece is dead. I spoke to Sheriff Kern yesterday. I'm not sure who says that the premium can be between 10 and 20% of the bond amount. I don't know why even say that, if it's not even taken into consideration as far as what the bond companies give. For all I know, this man could be free on a 3% bond. 3%. That's just $3,000. My niece's life is worth way more than $3,000. And all I ask is that bonds, they need to be, I don't know why he's out free right now. Again, my niece is dead. Yesterday, there was some sort of meeting about a police officer. That criminal, there's no bond for him. Why isn't there no bond for people that are killing our innocent people, Yes, we back up Jerry Garcia on, we need more boots on the ground. We do. And it's not politics. Thank you.
Thank you for your words. After this last comment, we will address the motion to go into executive session regarding this item. Counsel, could you please state your name?
My name is
And
Stephen.
then-
My name is Stephen Bell. I'm a practicing attorney. I'm quite often before this board as a representative of bail bond companies or corporate sureties. What many of you probably don't know is, at any given time, 50 to 60% of what I do is practice criminal law. I've represented criminal defendants in the private world for 25 years. And we want to point fingers, and everybody wants to look and determine this is the problem, that's the problem. The reality is, what is the solution? Setting 10% bond and require people to pay 10%, that's not going to solve your problem. Because if you look at the cases coming out of your jails, for example, Judge, I would ask you, one of the cases that you discussed, and there was victims, was an individual who was out on a PR bond and ultimately murdered someone. The bail bond community and charging a percentage is not going to solve your crime problem. The bail bond community serves very many valuable things. They are the conduit between jail, the courts, and the prosecutor. They provide a very valuable service to my clients. And I know in many instances when you hear these stories, and I see them a lot, they are the ones that assist to get these people to court. They are the ones, when there's a problem, as mentioned before, will let the courts quite often, before the court or prosecutor even knows there's a problem. Their goal is to make sure that person comes to court. It's rather ironic that I stand here before this board, where over the last several years, as the other lawyers spoke, we have been letting people out the door. It's just those minor misdemeanors, they're no big deal. And there's no repercussion for failing to appear. They just get another PR bond. There are many parties that are a part of this, not just the bail bond community. And as the sheriff commented, I think before the board passes some harsh rule that I will tell you, I practice in many counties around the state, and this is not even being talked about in any county that I'm aware of. I practice in criminal law in 15 to 20 counties. Bail is set out in the Code of Criminal Procedure as to how it's to be set, and there are several conditions that are tied to it. Obviously, the nature of the offense, the danger to the community, the capability to make bond. That bond is not supposed to be punitive in nature to keep someone in jail. And our law doesn't require that at the state level. We have a constitutional right to a bond. That's why quite often, many of you that don't know might see somebody with a $3 million bond for capital murder. The reason they're getting that bond in our state is because the law allows for it, while other states can no bond it. as the gentleman just spoke, they had legislation to give the judges some of those options in the prior legislature. That didn't pass. I would ask this board, before you pass a rule such as this, that you're so focused on the bail bond community and to try and force them into a box that I would agree with Mr. Good is price fixing. I don't believe you could do it. I would agree with the sheriff that we should look at all the parties involved, and I think you should ask for an attorney general opinion.
Thank you. That is our last comment on this agenda item.
Madam Chair, I move we retire to executive session for the purpose of receiving legal advice.
Thank you. Does anyone have any objection to that motion?
Point of order.
I have a question for the county attorney's office. Does this body have the ability to use executive session?
Does this body have the ability to go to executive session?
Yes.
Thank you. We have a motion on the floor. Do we have a second?
I have I would
Any
like to
discussion? Go ahead.
I would like to just discuss before we move to executive session, so.
Yes, sir.
If we could just hold off on that
I
real quick.
recognize you, sir.
Yeah, thank you, Madam Chair. Just quickly, I want to thank everyone that took their time to be here. Obviously, it's an important issue. First and foremost, above everything, I want to just offer condolences to all the families and supporters of the victims, because ultimately, we all talk policy, we all talk business, percentages and all that, but there's a real victim, many that are not in this room, and so our condolences go out to you. To the bail bond companies as well, look, I think they are an important party to this. I think that they do provide a valuable service, and I think that that's an important consideration. We can't just paint everyone with a brush. I'll tell you, though, that in my experience, and I go to many of those scenes late at night or at all hours to see firsthand what's going on in our community, I get a sense that we've lost a sense of accountability out there for whatever reasons. And what I said at the beginning still holds true regardless of what the ultimate decision is here. To say that, in my opinion, the bail bond companies are not shouldn't be or viewed as a scapegoat. It's an entire system. And I think that ultimately we have to move to an intentional-based system of corrections. I've been saying that for years, because I do think, and I agree with what you're saying in here, it's a red herring if we think that putting 10 or 20% or whatever is going to keep us safe. At the end of the day, we got to know that we've got to be looking at risk. And if somebody keeps committing chronic offenses, they need to be in jail until they get their day in court, in my opinion. And I'll tell you that in our jail, we've never seen the profile of so many individuals that are prone to violence, because we see it against our detention officers, we see it against each other, and we know that eventually many are coming out. We've never seen maximum classification. We've become like a prison system here locally. That's how serious the issues are. But I think that we're missing the boat if we don't look at all the issues of this. And I know that O'Donnell's been brought out. Look, I'm saying at the end of the day, we have to follow the Constitution as a community. There are people that are entitled to not be locked up in a pretrial basis of a crime. I mean, there's a lot of nonviolent individuals that made a mistake that should be reconnected with families and then have their day in court. But in this environment, when there's a case backlog and people are out by any measure, whether it be PR or cash bond or anything, and it takes a year, 2 years, or anything for them to be accountable, the odds of reoffending are going to be high. And so we've got to make sure that we don't just have tunnel vision on this meeting and think that this is going to solve everything. I mean, we'll deliberate, we'll look at the evidence. There's a sense of urgency, Judge, I agree with you. We have to do our due diligence. But at the end of the day, I just don't want anyone to leave here thinking, oh, we solved everything, it's now 10%. Because that, in the end, is not. And I want to just point out again that our team, I want to commend Sergeant Sisto de Leon and his team, looked at this, and the vast majority are requiring or charging whatever, the 8 to 10%. And so we can't paint everyone with a broad brush and say it's the entire industry, because it's not. And I think we need to engage. I spoke to Mario earlier about we all need to work together, engage, even when we disagree, or how do we improve the system. But we need accountability in our community. We need to make sure that at the end of the day that we're looking at risk and making these bail decisions to begin with. And if someone needs to stay in jail, then we need to find, and if they're being revoked or whatever, let's get them back in. Let's not give them another PR bond or any of that. They need to be in jail. We can't, and too often, when I go out to these scenes, I hate to say it, it's almost like I already know what they're going to say. He's out on bond. he's a chronic offender. That's unacceptable, and as a community, we need to say, that's not acceptable. We need to make sure that we're holding people accountable and holding them by all mechanisms, not just bail, but all mechanisms, pretrial services, how we're, sometimes we don't even know that. We don't oversee that GPS monitoring system. All that needs to be looked at, and gaps that need to be fixed. And so I'll yield, because I could talk about this all day, but again, we need to make sure that we're being fair and making sure that people that may be caught up because some type of minor drug offense or nonviolent or something like that, that they're given an opportunity in due process and their cases could be moved quickly and they have a chance to reconnect with their families. Because as sheriff, I think too that every year we have 90,000 kids that have a parent that's locked up in our jail. That's impacting a lot of people in this community. And I'm talking about violent offense, I'm just saying overall. So we have to be smart and thoughtful, but as Texans, we should draw the line and say, you know what? Violent crime is unacceptable, and we're gonna, by all means, make sure that we're changing laws, we're modifying rules and everything, because we wanna make sure that there's accountability. And I think that that's lacking in a lot of different levels, and we need to make sure that we're being thoughtful and making the right decisions when it comes to this work. But I wanna thank the board, Sister De Leon, for always being the rep, but this is an important discussion and I didn't want to miss it. So thank you, Judge, for the time.
Thank you so much. Just quickly addressing Mr. Mario Garza, it's my understanding that after the death of our chair, Mr. Strickland, you have been elected and have been active as a representative of the bail bond industry for less than a day. Is that correct?
Yes, ma'am.
Okay. There were formal processes in place in order to find a replacement for Mr. Strickland. A replacement has been found, and he has been sitting on the board in his first meeting. And as we know, the bail issue, having an ability to have bail, the right to bail, is addressed in the United States Constitution as well as the Texas Constitution. So there's a lot of reading to be done and a lot to go over before everyone gets their facts clear and we're able to make a reasonable decision either way. Okay? So quickly, we have a motion on the floor by Council McKinney regarding...
May I be recognized just for 2 minutes?
Well, okay.
I was going to ask the same
To speak.
Go ahead.
Okay, we're going to recognize you for 2 minutes, and then Council McKinney, and then shortly after, we're going to address his motion. Okay, we're kind of stretching it because there's a motion on the floor, so go ahead.
It's ironic because I was in this room, in this very room, standing at that very lectern in 2019, speaking about accountability and balance, about the O'Donnell settlement and its approval. And I sat there and I explained to Adrian and Lena that this O'Donnell settlement had no accountability and balance. So if history shows you anything, I was in that mindset 2 years ago. I started noticing it in 17 when we had 21,000 PR bonds already. So it was already snowballing. I'm a bondsman, I'm a human being. I started engaging the subject by going to Crime Stoppers, going into a room, mind you, where people didn't necessarily like a bail bondsman. But there I was, because I was trying to capture the human side of what people were going through. So here we are now. I was at that lectern and I was trying to explain about accountability and balance. And did I ever expect that we would be here? No, but we are, and I'm saddened, and I am a bondsman, but I'm a human being before that. So all you hear, I've met with families, I've cried with them, I've looked them in the face. I don't go grandstanding on TV about condolences or any of that. I have to look you in the face and feel your pain at some point. That's the best I can do because I know what's going on is wrong. So thank you.
Thank you very much. We're going to recognize Council McKinney.
Thank you. I promise this is going to be very brief. With respect to the sheriff's comments, for those of you who don't know, the Texas legislature considered a lot of potential changes to bail bond laws in the state in the last session. Some of them would have gone much, much further than what ultimately passed. There are new risk assessments, criminal history requirements that are going into effect, at least supposed to go into effect April 1st of this year. That will make that risk assessment and evaluation of prior criminal history easier for the sheriff's department, easier for the judges, easier for prosecutors, easier for defense lawyers. that was a major piece of the legislation passed this last session. The legislature also passed a number of additional bills that would limit the ability of PR bonds and eliminate them in certain offenses, not misdemeanors, generally not misdemeanors. And certainly I don't think the legislature could change anything that the O'Donnell settlement did with respect to misdemeanors. With respect to violent felonies, sexual felonies, the legislature eliminated the ability to get PR bonds in many of those cases. I tell you these things not to give you a law lesson, but so that you know, at least in my opinion, the place to address risk, the place to address policies on who should get a bond, who shouldn't get a bond, what the conditions should be, properly belongs in the Texas legislature and in the courts. This board is a regulatory agency of the licensing of bondsmen. We don't get to make decisions about who should get bonds and who shouldn't. We don't get to make decisions about who's at risk or who isn't. Those are decisions that are allocated by the law, or as one of the speakers put, everyone's held to the standard. And the standard is you have to have a legal basis to do something before you can do so. And there are entities, the legislature, the governor to sign it, the courts to implement it, and to do the things they're required to do. Those are the entities that have the power to address many of the items that have been talked about here today. So with that, I would renew my motion to move into executive session to obtain legal advice.
Thank you. I will address that motion. This is a factor, the factor of safety of the community is one of many factors that is taken into consideration when placing any bail of any amount. The factor of safety to the community is of paramount importance to our community, and this board is experienced in regulatory matters and also procedural matters pertaining to the purview of our board, okay? This idea is a new idea, and considering factors such as the gentleman being on the board less than a day and other factors of equity, it is 50% likely that we may vote on this today, or perhaps we will vote on this in a month. But nevertheless, the purpose is to have clarity and transparency. And on behalf of myself, prior to becoming a judge, I was a practicing attorney full-time for many different years. And I dealt with facts that no woman should have to see with my own eyes. And for the victims and for the litigants and for everyone involved, you put everyone together, we have our justice system. And in our country, we believe in our Constitution and equal justice under the law for everyone. So nevertheless, thank you for being here. Thank you so much for your comments. At this time, I have heard no objection. So the Harris County Bail Bond Board will go into closed session on this agenda item number 6 to consult with the board's attorney pursuant to section 551.071 of the Texas Open Meetings Act. The time is 3:24. Thank you, sir. Thank you, everyone involved.
Board.